Smoking is a very interesting one, actually, particularly with marijuana legalization. I argued the first case in Ontario in 2008 that was upheld a no smoking lease. And since that time, it's gotten remarkably different because of the sort of the public attitudes towards smoking have gotten changed quite a bit. The new Ontario Standard Form lease, which again you have to use if you're a landlord renting a residential property of one of the prescribed classes, which is basically all residential property, except certain forms of government housing, etc. There's a specific form that you have to use, and the form has a specific space on it where you can stop smoking in the unit, or say no, there's no smoking permitted in the unit, or rules associated with smoking. But really, that doesn't matter very much because, again, in order to evict someone for smoking, you're going to have to trigger one of the grounds of eviction that the Act allows, which would be either causing damage to the property or interfering with the reasonable enjoyment of other people. And so let's say, for example, you sign a no smoking lease and you live in a house and there's no one else who lives in the house. It would be difficult to prove that the smoking interferes with anybody else's enjoyment of the property because there is nobody else, and it would be difficult to enforce that. Conversely, even if the lease doesn't contain a provision of smoking, but somebody moves in upstairs from you who has a horrible allergy to smoke, and it does interfere with their reasonable enjoyment of the premises, then conversely you can generally, subject to certain limitations, etc., enforce that, regardless of whether the lease says you can or not.
Okay. But the lease does provide a space where you can say no smoking, or what are the rules?
Yeah, for what it's worth. But again, it's often not worth very much when you look at the actual practical side of enforcing that.